Welcome to EU Privacy for All, Session 34 on GDPR, Article 38, Position of the Data Protection Officer. Article 36 on the position of the Data Protection Officer was finally renumbered Article 38. It sets forth that the controller and the processor shall ensure that the Data Protection Officer is involved properly and in a timely manner in all issues which relate to the protection of personal data. The controller and processor will also have the obligation to support the Data Protection Officer in performing the tasks referred to in Article 39 by providing resources necessary to carry out these tasks and access to personal data and processing operations, and to maintain his or her expert knowledge. Both controller and processor will also have to ensure that the Data Protection Officer does not receive any instructions regarding the exercise of those tasks. They will have to ensure that it will not be dismissed or penalized for exercising those tasks, and that the DPO shall directly report to the highest management level. Data subjects may contact the Data Protection Officer on all issues related to the processing of their personal data to the exercise of their rights under the GDPR, and the Data Protection Officer shall be bound by secrecy. Finally, the DPO may fulfill other tasks and duties, and the controller or processor shall ensure that any such tasks and duties do not result in a conflict of interests. In Recital 7 of the 15 December 2015 GDPR draft, it was specified that the mandatory appointment of a Data Protection Officer was deemed acceptable in strictly limited cases. In Recital 77 of the final draft, adopted in May, it was mentioned that guidance on the implementation of appropriate measures and on the demonstration of compliance, especially as regards the identification of the risk related to the processing and the assessment of those risks, could be provided in particular by means of approved Code of Conduct certifications, guidelines provided by the Board, or provided by the Data Protection Officer. In different provisions regarding an obligation to communicate contact details of the DPO, the GDPR stresses that the DPO is a key tool in the compliance to be demonstrated by controllers and processors. Such is the case regarding the information of the data subjects in Article 13 and controllers' records of processing activities, or also regarding notification of a personal data breach, prior consultation of a supervisory authority, or in the frame of BTR's assessment. The Directive 95/46 framed the exercise of the activity of data protection officials, mentioning that it should act in complete independence, that Member States may provide for the simplification of or exemption from notification based on the appointment of a personal data protection official, and refer to prior checks regarding the existence of data protection official. What should accountable data controllers and processors get prepared for? First, controllers and processors will have to properly and in a timely manner involve the Data Protection Officer on all data protection issues. They will have to ensure that the support of the DPO will be provided, notably regarding resources necessary and access to processing operations, and also in order to maintain the knowledge of the DPO. They will have to ensure that the Data Protection Officer will not receive any instructions on his or her tasks and will not be dismissed or penalized for performing his tasks. He will also have to report directly to the highest management level. He will have to be bound by secrecy or confidentiality. And controllers and processors will have to check that the DPO exercises other tasks without any conflict of interest. Data subjects will have to be informed that they can contact the data protection officer on all issues related to data protection. The contact details of the DPO should be provided accordingly. Concretely, it means that the controller or the processor should consult the data protection officer on core assessments regarding data protection impact assessments, binding corporate rules, data breaches, or prior consultation of supervisory authorities. It will have to help identify risks related to the processing, their assessment, and best practices to mitigate those risks. So the question triggered now relates to how to define the level of resources to attribute to the DPO and how to ensure the absence of conflict of interests. EDPB guidance on the independence of the DPO and on data subject consultation will be key.